It's really a pleasure to be here. Let's start with a roadmap to the presentation. The presentation is not intended to constitute legal advice. If your organization requires legal advice, you need to go out and find a qualified attorney or tax professional who understands all about the incorporation and tax exemption status. The presentation is intended to provide lots of useful legal information. I hope you find that the presentation is adequate in that respect. And now, we have a web poll. What stage of development is your organization in? Please indicate which answer best describes your organization. Well, we're about equally split between organizations being in the idea stage, organizations having already incorporated, and organizations that have both incorporated and obtained their 501c3 status. I'll try to proceed accordingly and be all things to all people. That doesn't usually work out very well, but do our best. Okay, now the roadmap to the presentation. The agenda for this afternoon. First part of the agenda is really essential if you're in that stage of not yet having incorporated or obtained tax exemption, and that's asking good critical questions about whether or not your organization is ready to proceed with the incorporation and 501c3 tax exemption process. Part 2 will be a description of the not-for-profit incorporation process. Part 3 will be all about the holy grail of this afternoon's presentation, which is applying for, and what the holy grail is actually obtaining, that letter from the IRS that describes your organization as being exempt under Section 501c3 of the Internal Revenue Code. And Part 4 is the catch-all section, other considerations. We'll talk about a number of things, including being organized and then operating exclusively for charitable purposes under Section 501c3 of the Code, fiscal sponsorship, and some related issues. Okay, let's move right into Part 1. And look, we have another web poll. And the question is, if you have a mission statement and activities description, you are ready to incorporate and become a tax-exempt organization. I'm not sure that there's a right answer to this question, but I'm going to betray my prejudice about at least how to approach the question and begin to answer it as we discuss this section of the presentation. And let's start with mission. Okay, before we even get into the issue of a good description of activities and a budget, does your organization have a concise mission that it can express in let's say 1 to 3 sentences, that's catchy, that's compelling, and that describes an activity that's cognizable to the IRS under Section 501c3 of the Internal Revenue Code? Let's just make a point of reference for the future. If I refer to 501c3 organizations, talking about organizations that have obtained recognition from the Internal Revenue Service as being exempt from federal taxation under Section 501c3 of the Code. Those organizations are also able to receive tax-deductible contributions for donors. Because of those two characteristics, most of the nonprofit organizations that we encounter want to become 501c3. It's one thing to have a mission. It's another thing to know how you're going to go about undertaking that mission. That means you need a description of the activities your organization will undertake in furtherance of the mission. I do think that that is pretty indispensable to have before you embark on the process. Plenty of organizations move forward without it. Pardon me. But then when they get to the stage of seeking recognition as tax exempt under Section 501c3 from the IRS, they find that not having that description of activities stops the process and makes them go back to the drawing board and come up with the plethora of detail that the IRS will require for an organization that seeks to be recognized as 501c3. When we get to the section on obtaining 501c3 exemption, we'll talk about this in more detail. The next part is really critical. You must have a group of people who are highly dedicated to the mission of the organization, committed to carrying it out, and prepared to do the hard work that will be necessary to turn it into a reality. Some of these people have to be willing to become the directors and officers of the corporation. The corporation can't move forward without having good fiduciaries, directors, and officers who are prepared to carry out the work and take responsibility for it. So the answer to the polling question, It's a darn good idea to have a description of activities and also a budget, because you must know how these activities are going to be funded. Good idea to have this stuff before you incorporate and seek tax exemption. Looks like we've already talked about budget. Fundraising plan is related to budget. You need to get the money somewhere, if not through fundraising, then through fee-for-service activities. I'm not going to talk much about that today, except to say that the fee-for-service activities must be directly related to the charitable mission of the organization. If the organization wishes to be able to treat the revenue generated from that fee-for-service activity as revenue that's exempt from federal taxation. Now, I may be betraying my own prejudice here, but I think that having legal counsel is extremely important, if not indispensable. Inevitably, there will be one or two organizations that proceeded without legal counsel, did a great job, and managed to get started. But think of having a nonprofit organization like running a business. It's not a good idea to start a business without counsel. It's also not a good idea to start a nonprofit organization without counsel. And we love bookkeepers and accountants, believe it or not. You might not have heard anyone say that before, but we do, because nonprofit organizations need to keep very careful financial records, and they need to keep track of the revenues and expenses in a way that's not typical of a regular small business. So that bookkeeper or accountant must either be aware of the reporting obligations of an exempt organization or be willing to become aware of those obligations during the course of providing services to the organization. Part 2, not-for-profit incorporation and related matters. Your organization has determined that it's ready to move forward. It has a mission statement, has some sort of description of its activities, and it has given at least some thought to financial matters, and now you're ready to incorporate. Here's how you go about it. The first step, if you hope to be recognized as a 501c3 entity, is to create a not-for-profit organization under state law. There are various types of forms that you might use. The best, in the sense of being probably easiest to follow, the clearest rules, the one that we see nonprofit organizations use most often, is a not-for-profit corporation formed under state law. Just to be clear, a not-for-profit corporation is a creature of state law, and a 501c3 entity, exempt organization, is a creature of federal law. In order to get to the 501c3 level, you must first create a nonprofit organization at the state-based level. The way that you create a not-for-profit corporation is to draft a certificate of incorporation. I see that we have another web poll coming along, and that is, which of the following purposes can a not-for-profit corporation state in its certificate of incorporation? Religious, charitable, scientific, literary, educational, or all of the above? Looks like everyone is giving right answers. That's sort of a trick question. Okay, let me just say that it's all of the above, but the IRS uses the term charitable both to refer to charitable activities as they're generally understood by the courts or expressed in the dictionary, but also to refer to the other activities that it recognizes as C3 activities under the Internal Revenue Code: religious, scientific, literary, educational. Sometimes the term charitable will be used interchangeably to describe all of those activities without having to go through the laundry list. So it's also true that educational purposes are C3 purposes. I should make that clear. All of the purposes listed here are good C3 purposes, provided that they're carried out in a manner that the IRS will recognize as being consistent with the Internal Revenue Code. And you know, you've heard the expression, the devil is in the details. That's certainly true when it comes to the Internal Revenue Code. Okay, we're ready to draft our Certificate of Incorporation to state one of those religious, charitable, scientific, literary, or educational purposes that will qualify the organization as a good C3 organization. And you can see that we've given some examples. These are by no means inclusive of all of the different kinds of charitable, social welfare, economic development, health, arts and cultural organizations that may be recognized as being exempt from taxation, federal taxation, under Section 501c3 of the Code. The way to take your Certificate of Incorporation, which we're in the process of drafting, and create a valid corporation is to file that certificate with the Division of Corporations in your state or the state in which you intend to create the corporation. However, prior to filing the Certificate of Incorporation, which we will also refer to as the charter, another name for it, and it's a somewhat handier reference, you might have to get clearance from a state agency. Just for example, if you're forming a senior center, and there's a state or local agency that regulates the activities of senior centers in your state, or you're forming an after-school program, and the Department of Education wants to weigh in. They want to check your Certificate of Incorporation, make sure that it's got the right language. They want to make sure that, in fact, you're not forming a school, because if you form a school, you have to be accredited before your certificate will be accepted, or at some point during the acceptance process. And so you might have to go to a state agency. How will you know? Well, in New York State, you can go to the Division of Corporations website, and you can check. And there is a section that talks about the types of agencies that review these things. If you're not in New York State, you can check the Division of Corporations website or check the Charities Bureau website in your state, see if it appears, and of course you can check with legal counsel. We've provided a form of Certificate of Incorporation, which is a good form. It's a very good form. I drafted it, but it's just a form. And again, you have to check with local law. You have to check with state law. Paragraph 3 of the form we're looking at right now says the corporation is organized and operated exclusively for 501c3 purposes. That's essential language. You should put it in. I know there are different theories of drafting certificates of incorporation, but you want to make this as easy on the revenue agent at the IRS who's reviewing your application for 501c3. Make it as easy as you can by putting it right up there just before you state your corporate purposes that you are organized and you will be operated exclusively for 501c3 purposes. Just a quick word about 501c3 purposes, and I think we'll come back to this during the section on obtaining 501c3 exemption, but you're going to want to state them in a way that the IRS recognizes as being good charitable purposes. If you're not sure, you're either going to have to seek counsel or you're going to have to do some tax research on your own and or take a look at the publications that the IRS has on creating and maintaining tax-exempt status. We've provided you with a set of useful internet links that you'll get after the program is over, and then you'll see it. And it's useful. You can refer to it. It's got links to the relevant parts of the Internal Revenue Service website relating to exempt organizations, including Publication 557, which is really, really long. But just take a look at the section of that publication relating to 501c3 organizations and the types of corporate purposes that are cognizable to the IRS as good C3 purposes. Bylaws. You'll see that we've attached a form of bylaws to the materials as well. You'll be able to access those later on, too. Bylaws tell you how to run your organization. You must pay attention to them. They may be long and nearly impenetrable, but if they're reasonably well drafted, they will have a table of contents. You will be able to figure out where the section is on giving notices of corporate meetings, the section on how often to hold elections, how to conduct your elections, who gets elected, what their titles are, what their responsibilities are, and other essential matters for running and maintaining a nonprofit organization. And one of the reasons that this is so important is that unless you run your nonprofit in compliance with the law, with the bylaws, and with the Certificate of Incorporation, anyone who takes a look at your organization from the outside, whether it be a potential funder or an auditor like the Internal Revenue Service, or if there's a lawsuit against the corporation, we hope that doesn't happen, but you never know. They're going to take a look at your bylaws and see whether or not you're running your organization in compliance with the bylaws. So do it right. The bylaws, like the other forms that I've attached, are intended to comply with New York State law. I think they're a good form, but consult your local nonprofit law to make sure that they're adequate in all respects for the place where you form your nonprofit organization. This is part of the table of contents of the bylaws as exhibited on your screen now. After you've filed your Certificate of Incorporation with the state, it's been accepted for filing, you receive a filing receipt. Ask for a certified copy, by the way, because the IRS is going to expect you to provide the certification for the charter, for the certificate of incorporation, when you file that application for 501c3 status. So you've got that certificate of incorporation in hand. Now, I want to use a shop-worn metaphor to describe what you have now. You have a boat in dry dock. It might be very shiny, it might be very pretty, and it might have great capacity, but until you hold the organizational meeting, you're not going anywhere. If you do without holding the organizational meeting, you're not complying with your legal responsibilities. You might be held accountable by any of the groups that I mentioned before, legal, funding, state-based, or otherwise. And therefore, this is an essential piece that we're talking about today. You should prepare a notice of organizational meeting, agenda for the organizational meeting, and after the organizational meeting, minutes to memorialize what happened. And you're thinking, how am I going to do that? Well, don't worry. We've provided sample documents for each of those functions. They all come, I hate to keep repeating this. Maybe this is the last time I'll say this, and we'll let this be a continuing disclaimer that applies to the rest of the presentation. These are all good documents under New York state law. I think you'll generally find that they're good documents under the laws of other states as well. But check with your local not-for-profit corporations law, check with your Charities Bureau, check with a legal authority in your state who understands nonprofit organizations. At the organizational meeting, your organization will adopt bylaws, will elect directors and officers, will probably pass a banking resolution, will authorize some officer of the corporation to file the Form 1023, which is the application for recognition of tax-exempt status under Section 501c3 of the Internal Revenue Code. Maybe your state law requires other stuff to happen as well. Oh, there I go again. Hold good meetings. This might seem obvious, but if you've represented nonprofit organizations the way that I have, you'll realize that it's not obvious. The first thing we do with an existing not-for-profit corporation is say, let us see your minutes, let us see your resolutions, let us see your notices, let us see your contracts, let us see everything that you're required to file periodically or otherwise with the state or any other regulatory authority, and all too often we're met with stares or some shoebox that's filled with more or less relevant documents. So do it right, give proper notice, create agendas, make minutes, take minutes, and adopt the minutes at the next meeting. The minutes don't become final until they're adopted by the corporation. You propose them. If there are no changes, you simply adopt them. If there are changes, you make amendments, and then you adopt them. Finally, be consistent. Okay, just to reassure you that there really is a notice of meeting attached to these materials and a agenda attached to the materials as well. Thank you. And minutes. What I tried to do with these are minutes of an organizational meeting, is to make some blend of these minutes are going to look formal to you, but to me they represent some blend of formal and not quite so formal minutes. And I did that deliberately just so that you could take a look at it and think about theories of drafting minutes. On the one hand, you'll see language like a motion was made, seconded, and unanimously passed. That's fairly informal. On the other hand, when you actually look at the minutes, you'll see language as, whereas the corporation has determined that it's in its best interest to open a bank account, and whereas the corporation has made an investigation of the local depositories that are available, and so on and so forth. You can take a look at the minutes, and what you're looking at is different theories of drafting. The important thing is to keep minutes, and the more often you do it, the better you'll get at it. We mentioned before that the not-for-profit corporation is not the only kind of nonprofit organization that you can form to get C3 status. You could form a limited liability company with counsel, please. The limited liability company is trickier because typically a limited liability company is a for-profit business, and the members of the limited liability company are the owners of the business. One thing that we neglected to say before is that no one owns a nonprofit tax-exempt organization. It belongs to the public. It exists to carry out good public charitable purposes. And therefore, the only way you can form a limited liability company and make it into a tax-exempt entity is to make the members of the limited liability company exempt organizations themselves. You could have an unincorporated association. I happen to think that that's a bad idea. You should be able to pass muster as a corporation with the state and not have to go about forming an unincorporated entity to get C3 status, in any event, the IRS will expect to see articles of association, very much like a charter, and will expect to see bylaws or an operating agreement, because the IRS has to know that you can elect directors and officers according to prescribed rules. There might be some case for tax reasons in which you would form an unincorporated association, but I can't think of it offhand, and don't do it without counsel. Finally, a trust is another form for creating a nonprofit organization, probably not the type of nonprofit organization that you want to create, which is a nonprofit that carries out charitable activities, not a nonprofit that funds charitable activities. Charitable organizations, and this includes not-for-profit corporations that engage in charitable activity and haven't yet been recognized as exempt by the IRS, are required to file with the state Charities Bureau in the state in which they do business. That means initial filing and annual registration thereafter. Please check. New York State, you can go to the Charities Bureau website. That's true in most states in which your organization is located and operated. I think that in the web links that we've provided, we have provided a link to the 50 states Charities Bureau directory. So you should go to the directory for your particular favorite state and find out what the requirements are on the Charities Bureau website. That's true in most states in which your organization is located and operated. I think that in the web links that we've provided, we have provided a link to the 50 states Charities Bureau directory. So you should go to the directory for your particular favorite state and find out what the requirements are there. We are almost ready to march into Part 3 on obtaining and applying for 501c3 status, but before we do, we're going to open the floor for questions.
So when you're talking about the organizational meeting, what is the preferred method of sending the meeting notice?
I would send the meeting notice by mail. I was asked this question just recently by someone who asked me whether or not they could send the notice by email. Well, in New York State, in order to send a notice by email for a not-for-profit corporation, the bylaws must provide that notice may be given by email. We have a catch-22 here. We haven't adopted bylaws yet. So to be on the safe side, it may be a bit of a nuisance, especially if you're accustomed to communicating by email the way that we all are. Send the notice by mail and make a mailing list of everyone that the notice went to. And if you have any reason to think that anyone is going to object and state that they didn't receive notice, you should probably also get a certificate of mailing for each notice that you send from the post office. Typically, that's not necessary. But if there are people who could potentially create a nuisance within the organizational structure, I know that never happens in nonprofit organizations, but if that is true in your particular case, think about that as a way of proving you've actually given the notice, and then when you hold the initial organizational meeting, make sure that you file the notice of meeting together with the mailing list, together with the certificate of mailing, and those documents will become part of the minutes of the meeting and the records of the corporation.
Okay, thank you.
Okay. So now we're ready to go ahead and to seek the Holy Grail, 501c3 tax exemption. As we said before, organizations like to get 501c3 tax exemption because revenue that is received by those organizations is exempt from federal tax, and because donors can make donations to those organizations and then deduct those donations on their tax returns. Before we continue with the 501c3 exemption practice, let's move on to another web poll. This question is, an organization, it's a statement, sort of, an organization can be tax exempt without receiving an IRS tax determination letter. True, false, or don't know? An organization can be tax exempt without receiving an IRS tax determination letter, but most are not, and even the organizations that could be usually choose to seek exemption from the IRS and get their hands on that tax determination letter to eliminate or resolve any ambiguity regarding their status and to give certainty to their donors. For example, a church or a nonprofit organization with less than $5,000 in annual gross receipts that acts in a manner that's consistent with Section 501c3 of the Code is tax exempt on federal revenues and can receive tax-deductible contributions whether or not it's received that C3 recognition letter from the Internal Revenue Service. Again, best practice, get the C3 letter. Some donors won't give you money unless you have it. And if you get it, you will know that you've already passed muster with the IRS regarding how your organization is organized and at least how you purport to operate. Because the IRS will have to review those issues prior to passing on your application and recognizing you as an exempt organization. Well, we've already talked about this one, but the question of which nonprofits are eligible for 501c3 status, what we neglected to say before, although this falls within the ambit of what charitable organizations can do, in addition to the ones that we previously listed, organizations for the prevention of cruelty to children or animals, organizations that engage in testing for public safety, like Consumers Union, and organizations that foster national or international sports qualification. Let me back up on that one. Organizations that foster national or international sports competition can all qualify for 501c3 status. Within this list of organizations, there is an enormous range. Don't assume that you don't qualify. Just for example, educational may also mean arts and culture organizations. There's a very wide range of those that do qualify for recognition under Section 501c3 of the Code. We're going to assume that your organization is going to seek 501c3 exempt status. You should go on the IRS website if you haven't already done this, and in the search box at the upper right-hand corner of the screen, just type in SS4. The website, by the way, which is referenced many, many times in our materials, is www.irs.gov. If you bring up Section SS4, what will come up is your application for an employer identification number in PDF form. It's a fill-inable form. Fill it out, press enter, and in a matter of minutes, your organization will have an EIN, or employer identification number. You're going to need that. It goes on the first page of the application for 501c3 status, which is that application is the IRS Form 1023. If your organization files the Form 1023 within 27 months after its incorporation or after its articles are filed, and if the application is granted, then the tax exemption will be retroactive to the postmark date of the application. This doesn't mean that you're tax exempt in advance of receiving recognition from the IRS. It's very important. An organization that holds itself out to be tax exempt that's not can be fined by the IRS. They're very serious about it. The fine can be up to $10,000 per day for falsely holding out the organization as a C3 when it's not. But what you can tell donors, or potential donors, is that you've applied and that your application is pending, and that if it's approved, deductions received during this 27-month period will be retroactively tax deductible. Filling out the Form 1023 can be a daunting task. It's a long form, and the instructions to the form are even longer, about twice as long. Well, don't throw up your hands in despair. Get help, and understand that most of the application is pretty formulaic. It's asking you for basic information regarding who the organization is, who's in it, what kinds of policies you've adopted, the activities you intend to undertake, and financial data. So the key parts of the Form 1023, the application for C3 status, are the corporate documents. We've already talked about this. Corporate documents have to be drafted in a way that will pass muster with the IRS agent who reviews your application. They include the bylaws and the certificate of incorporation or other organizing instrument. Probably the heart and soul of the application is the narrative description of the organization's activities. That's part 4 of the application, and you really have to state in very great detail what the organization intends to do, who's going to do it, what the qualifications are of the person who's doing it. Let me give you an example. The senior center that we talked about before, you would have to state what kinds of activities you plan to provide to seniors: recreational, social, educational, medical, nutritional, sports. That would have to be set forth in detail. You would have to state who is going to carry out those activities. Will you have counselors with experience? We have a licensed therapist on staff, people who have prior experience working with nonprofit organizations. The IRS wants to know what the qualifications are of the people carrying out the activities. Also, where will the activity take place? Is some public housing project letting you use its community room? Or are you going to have to go out and lease space? If so, how are you going to pay for it? The budget is a related issue. You don't have to put a budget in Part 4, but you do have to say how the activity is going to be funded. So what we talked about before, which is starting from the back end, before you even incorporate, you could pull the Form 1023 501c3 application from irs.gov and look at Part 4, and we'll go on and talk about Part 9, and look at Part 9. And if you can't answer those two questions in detail and provide the information that's required in detail in a highly particularized way, then arguably you're not ready yet to incorporate and seek tax-exempt status. And that's okay. You shouldn't feel discouraged. In fact, you should feel like this is a good thing, because before moving ahead and getting involved in all kinds of things that may create legal liability, you're going to create a firm foundation that you can use to move forward and feel comfortable about moving forward for the organization and achieving your charitable purposes. Part 9, the financial data. The IRS is going to ask you to provide a statement of revenues and expenses, everything coming in, everything going out, for a period of at least 3 years. And we'll also ask you to provide a balance sheet, a statement of all of the assets and liabilities that the organization has. It's not that hard to do. It might be a little intimidating when you first look at the application. You can read the instructions. Even though they are long, they're fairly clear. And you can seek help. You can seek legal help. You can also seek help from places like the Foundation Center and all the great technical assistance organizations that help nonprofit organizations. After you get your recognition letter from the IRS, well, let's back up. Before you get your recognition letter from the IRS, you still have to file the Form 1023 application for 501c3 status together with the user fee. If your anticipated annual revenues are under $10,000, the user fee is $300, and if the anticipated annual revenues are $10,000 or more, then the user fee will be $750. So that's one of the fees you can start planning for. You can also think about any fees that are related to filing the Certificate of Incorporation, getting a certified copy, and getting any waivers or consents you have to get from state agencies, in case you want a complete list of all of the fees that are associated with getting started. How long does it take to get that 1023 letter? It's a really good question. There really is no single answer. I've seen it happen miraculously in as little as 2 months. I think it's even less. I didn't say that. You didn't hear it. It's not going to happen for your organization. And as much as almost 2 years for an organization that I was counseling, and it was also counseled by Victoria Bjorklund over at Simpson Thatcher, who is she's kind of like to nonprofit organization law in New York what Mick Jagger is to rock and roll. So even if you've got all the right people on board, it could take a long time, and be prepared to navigate a choppy course if you have to. But once you get that C3 letter, which could take 3 to 6 months, more likely in the 6-month area after you file the 1023 application for C3 status, you have to get the state and local tax exemptions. That's not that hard, because the state is probably going to assume that if you've already been recognized as an exempt organization on the federal level that you qualify, and at least in New York with respect to the state corporate tax exemption, you have to answer some questions, but if you provide a copy of your 501c3 letter from the IRS, you should be good to go and get your state exemption. So now we're going to take questions related to Part 3.
Okay, we have a few questions in the queue. Who determines the deduction percentage of the donors? Will be allowed to deduct? Is it determined by the IRS or by the organization?
That's a tax question for the donor. That's determined by the Internal Revenue Code, and that you don't want to answer that question for the donor. Don't give legal advice regarding tax deductibility and the amount of a donation that will be tax deductible. What you should say is that the donation is tax deductible to the extent permitted by the law. For all we know, the donors used up all their tax-deductible contributions for the year, and they're not going to get anything back. That could happen. Don't make any legal conclusions related to tax deductibility.
Okay. And can an organization operate under a fiscal sponsorship until they obtain a 501c3 status? And what are the pros and cons of it?
Oh, Kim, I am so glad that you asked that question, because that's a great segue into the next section. I'm going to answer. It doesn't mean that we won't take more questions, but let me answer that question. I won't have to deal with that slide later on. We'll just pass over it quickly. Fiscal sponsorship. So what's a fiscal sponsorship? For an organization that hasn't received its C3 status yet, but wishes to receive tax-deductible contributions. By the way, this could work for an individual as well. We're not going to get into this in detail, but individual artist or educator might also be able to use the same form in order to receive tax-deductible contributions. The organization known as the project that doesn't yet have C3 status affiliates with another organization known as the sponsor. I'm just using these terms for convenience, but they're also generally known in the field. The sponsor is an organization that has already obtained 501c3 status and that has similar corporate purposes and a similar mission. There has to be something within the ambit of the mission of each group that is similar. The project affiliates with the sponsor. There should be a written agreement. It doesn't always happen, but wherever there's not a written agreement, there's a potential for discord and liability and also problems with the IRS. A written agreement that sets forth the circumstances under which the sponsor, which is the existing C3 organization, can receive contributions on behalf of the project, which doesn't have it yet. And the project is so closely affiliated with the sponsor that the IRS essentially treats them as a unit for purposes of exemption under Section C3 of the Code. The sponsor receives the contributions, and the sponsor, under appropriate circumstances, then releases the money to the project. This is not a fiscal conduit. People use this term all the time. I have this image of water rolling downhill inevitably without interruption. The IRS hates that. The sponsor has to exercise discretion and control over the expenditure of these funds. That's why the sponsor and the project have to have consistent purposes. That way, the sponsor knows when the project makes an application for funds and says, I'm going to use it to run this kind of an art exhibit. The sponsor, that is an art organization, knows whether or not that type of exhibit is a good C3 type of activity. So that's what you got to do. You have to affiliate with a 501c3 sponsor, written agreement, exercise of discretion and control, and it could work. I hate to say this, but the sponsorship agreement should be drafted by an attorney who knows what he or she is doing.
Okay, finally, we'll take Karen's question. When we showed a slide earlier which nonprofits are eligible for 501c3 status, there were a bunch of listing there, but it didn't have anything about arts or culture. So something like a dance company or any other arts and cultural organizations, would they be listed on the educational section? And if so, do they need to obtain another approval from Department of Education?
Well, great question. Arts and cultural organizations certainly can be and all the time are recognized as C3, but you want to take a look at Publication 557. You want to have your attorney do a little tax research. If you don't have an attorney, you might want to take a look at the Internal Revenue Manual, which you can Google and find. The section on exempt organization determinations has a whole section on arts and cultural organizations. There are a ton of them, but they can't be run any which way. They have to be run in a way that doesn't give rise to private benefit, that doesn't give rise to insider benefit, and your tax advisor or attorney would have to know a lot more about the way that you intend to carry out those artistic or cultural activities. The state might want to weigh in if it sounds like those activities are educational, and arts and cultural activities are educational under Section C3 of the Code. That's made plain by the Treasury regulations, which are the regulations promulgated to fill out and flesh out Section 501c3 of the Code. They make plain that these organizations can be educational organizations under Section C3. And so it is possible that the Department of Education in your state will want to see your charter, your certificate of incorporation, and make sure that the language is acceptable to them before they will permit your arts organization to file its certificate of incorporation.
Okay, that's it.
Fantastic. We're going to move on. No further questions. So now that you've received your C3 letter from the Internal Revenue Service, Mazel Tov, congratulations. It's good. You're ready to go out and do everything and collect contributions. You don't have a care in the world That's not entirely true. I'm sorry to tell you. I know you hate lawyers, right? The organization must be organized and operated for 501c3 purposes. We've already talked about the organizational test. The language in the Certificate of Incorporation has to say that this corporation is organized for 501c3 purposes exclusively, and that it's operated exclusively for such purposes. It also has to say, in terms of what the IRS calls the organizational test, they actually have an organizational test as well as an operational test. Your charter must say that if the organization is dissolved, the assets of the organization will either be distributed to another 501c3 organization or to a governmental entity for the accomplishment of some public purpose. So we've talked organized, let's talk operated. This is not an inclusive, or it's not an exclusive list of the kinds of activities that a exempt 501c3 organization can't engage in, but these are the activities that should be set forth in your charter as activities that you either won't engage in or that are strictly limited. First of all, political campaigns. An exempt organization cannot engage in any activity to influence in any manner the outcome of any political campaign, period. There is no intermediate sanction that can be applied to an exempt organization that engages in political activity. It's not written into the law. An intermediate sanction, by the way, is something between either no disciplinary consequences at all for the activity or stripping the organization of its C3 status altogether. That does exist for certain other kinds of activities that are limited under the code, but the only sanction for political activity is denying C3 status in the first place or stripping an organization that has it of its existing C3 status. Lobbying activity has to be limited. If you think that your organization is going to engage in a significant amount of lobbying activity, it should undertake an election under subsection H of 501 of the code that has to do with more significant lobbying. We're not going to get into that in detail today. We have memos on it. You'll find memos on it all over the place by Googling it. But be aware that if you engage in lobbying, you need to do so in a way that is recorded and is kept track of, and you must be aware of whether or not your state or your municipality has rules related to lobbying and registering as a lobbying entity the way that New York does. Just very briefly, financial benefit. There cannot be an excess financial benefit to insiders. There can't be an excess private benefit to outsiders. This doesn't mean that reasonable compensation can't be paid to directors or officers for activities that they undertake on behalf of the organization. Typically, however, a director will not be compensated for his or her work on the part of the organization if it takes place in the context of discharging his or her duty as a director. That's the way that we draft our bylaws, and that's a best practice. Officers can be compensated, and of course employees and others can be compensated for services that are performed on behalf of the organization. Finally, limited business activity that's unrelated to the exempt purpose. If you're running an after-school program and you are relying on fee-for-service, the kids' parents pay $5 or $10 per session, even though that might be considerably less than the cost of actually running the after-school program, that's a good business activity that is related to the organization's exempt purpose. And if it is related, then the revenue that you derive from that activity won't be taxable. That's good. That's one of the reasons you form a 501c3. However, if it's not related, if you decided to create a snack bar right next to the after-school program, and it wasn't just for the convenience of the employees of the program or the parents who pass through, it's open to everyone on the street. In fact, it has the best coffee and croissants and tamales on the block. The revenue that you generate will be subject to taxation, and if the amount of revenue that you generate exceeds a certain percentage of the organization's overall revenues, this will give rise to sanctions and to penalties. Public charities versus private foundations. If you're listening today, it's likely that you're planning to run a public charity even if you didn't know it. And I say that because public charities typically carry out charitable activities. Private foundations support them, or you can have an operating foundation. Especially if you're small, grassroots, carrying out activities, you're going to want to be recognized as a public charity because Your reporting requirements are considerably less complex. You need not take a portion of your organization's revenues and distribute it to another organization to further the charitable purposes of that other organization. Individuals may make, and corporations and foundations may make more generous contributions to public charities than to private foundations. And finally, public charities are exempt from the payment of certain taxes that private foundations are not exempt from. In order to maintain public charity status, the IRS over the course of time will typically want to see that the public charity generates its revenues from a wide variety of sources, indicating that it's actually supported by the public. Is reporting requirements for exempt organizations. And after you've obtained your C3 status, you still have an annual reporting requirement with the federal government. You probably also have an annual reporting requirement with the state government. That doesn't mean that the organization will necessarily be paying taxes, but it does mean that an informational tax return has to be filed with the federal government. It's called the Form 990. There's also a Form 990EZ and a Form 990N. You'll see that depending on the level of organizational revenue, you'll be required to file different variants of the 990, even if the organization's revenues are less than $25,000. And if you know about the way things used to be, you'll say that's not the case. Organizations with revenues under $25,000 needn't file. That's not true for any fiscal year that was completed after December 31, 2006. That means that for an organization on a calendar year beginning January 1st, you will have a filing requirement beginning in 2008, and you should check the link that we provided in our useful internet links to the new filing requirement for small tax-exempt organizations. Finally, if the organization does generate non-tax exempt revenue in excess of $1,000, that is revenue from unrelated business income that's not related to the accomplishment of the charitable mission of the organization, that organization must file a Form 990T. Hey, guess what? I've already talked about fiscal sponsorships. I don't think I missed anything. So that being said, we're coming in under the wire. We have time to answer some additional questions.
Since it does take some time to receive the 501c3 status, how does a startup organization go about in terms of soliciting grants from foundations? Would it be better off for them to work with a fiscal sponsor organization? Is there any other ways?
Well, I think that most donors want to see you produce a C3 letter and also produce good corporate documents, not just a certificate of incorporation and a charter. They want to take a look at your minutes. They want to take a look at your resolutions. It's likely that if you haven't yet obtained your C3 status, all of that may not be in proper condition. Even if it is, you still don't have your C3 letter. And therefore, if you think that there are donors out there who would like to make a contribution to the organization but can't or won't because you don't have your C3 status yet, you can try to affiliate with another like-minded organization with consistent charitable purposes that is prepared to serve as your fiscal sponsor. Now, that can be tough to find. The easiest area that I know of to find fiscal sponsors is arts and culture organizations. There are a lot of those. There are 501c3 organizations that exist for the purpose of serving as fiscal sponsors to other arts organizations. As to other fiscal sponsors, allow me to commend an excellent resource to you known as the Foundation Center. You might have heard of that today, which has the capacity to do research related to issues in fundraising, including fiscal sponsorships.
Okay, the next question is, what is the process necessary to change the name of an already existing nonprofit organization?
Well, if you filed a certificate of incorporation, you need to go back to your Division of Corporations. In New York State, it's quite easy. You go to the Division of Corporations website. You find the section on not-for-profit corporations. You find the document called Certificate of Amendment of the name of the not-for-profit corporation. You fill it out. You pass a corporate resolution that states that your board is in favor of changing the corporate name. You file that together with the completed application, and whatever the fee is, maybe $25 or $75 with the state, and you will get back a new certified copy of your certificate of incorporation with your changed name on it.
Can meetings be held as web meetings?
I think web meetings are great, but I wouldn't necessarily do the organizational meeting that way. And it's for the same reason that you don't give the notice of the organizational meeting by email, because web meetings should be authorized by your bylaws, at least in New York State. If you want to hold meetings by some form of electronic transmission, the Not-for-Profit Corporations Law provides that you can do it, but you have to specify in your bylaws that you can do it. So you're back to the same catch-22. Got to adopt bylaws. So maybe for that first meeting, go for the in-person form. I understand that could be a pain. I can think of ways of doing it if you absolutely had to, and then ratifying the action, nunc pro tunc, that is now for then. But be careful about how you draft the organizational minutes of that meeting. I certainly would want to see them before they were filed with the corporation. Okay, before we proceed with the questions, I just wanted to thank the people from the Foundation Center for making this opportunity available. This is going to be a great resource, and a quick plug for the sessions that are coming up. You need to know about everything, not just the legal aspects. You need to know about the governance aspects, following your bylaws, creating a great board, fundraising. I don't have the entire list in front of me, program developments. So do all 5 sessions. And if you do all 5 sessions, and then you come to the Community Development Project at Legal Aid seeking to start a nonprofit organization, boy, will you have a leg up on the process. Thanks, everyone, for participating, and thanks for your great questions.